Today's case follows Anthony Mendoza, a man with one of the most complicated probation histories you'll see in this courtroom. Originally sentenced for DWI third or more, a serious charge that already carries prison time, Mendoza was instead given probation. That was his chance at redemption. But what followed was a series of excuses, violations, absconding from probation, and even a new arrest in Houston for aggravated assault with a deadly weapon. This hearing is his last stand. Will the judge give him yet another chance or finally pull the plug on probation? Stay tuned, because this one takes a turn you won't see coming.
Good morning. Are you Anthony Mendoza?
Yes, ma'am.
And Mr. Mendoza was previously in court and entered pleas of true to counts 1 through 13 in a motion to revoke probation. Currently on probation for driving while intoxicated third or more. That was a 6-year sentence that was probated for 6 years. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, we have.
Are there any additions or corrections to that report?
No, Your Honor.
Not from the state judge.
All right, Mr. Parker, you may proceed.
Well, a couple of things I want to address. It's a situation I see quite a bit where he's ordered to have to scram and interlock. It's costing him $600 a month. And he's having to go to work, but yet he's not supposed to drive. And so he's driving with an invalid license. And then he's not able to work, and he can't afford to pay for the things, he needs to do, such as the 12-step program, the GED program, all those things require money. And that's one of the big issues. But the things I'm concerned about is that it says that he went to the safety relapse program. I'm not sure exactly what happened, but he says he never went.
Right off the bat, Mendoza's attorney leans into financial struggles. $600 a month for monitoring devices, transportation problems, work restrictions. It's a sympathy card, and it resonates with many defendants who claim probation is designed to make them fail. But here's the problem. Costs don't excuse violations. And when the judge hears driving without a valid license and constant alcohol violations, the excuses start sounding like patterns. Question for you. Do you think probation fees create unfair traps for defendants? Or is it just part of proving you're serious about staying sober?
He wants the opportunity to go back he wants to complete his probation. He wants to do the safety relapse. I'd like to hear what they say and what happened with that, but I'm sure there's an explanation. And I think you'd also like to address the court, Judge.
Well, let me first make sure I've got the timeline, because it appears that I see that safety he completed and then was placed on zero tolerance in the high-medium caseload. And after that, there was an issue where he was testing positive, again, for alcohol and cocaine, which I understand he denies the cocaine, but that's what this alleges. And in October of 2022, I'm assuming through an administrative hearing, was granted relapse safety.
Yes, ma'am. There was a motion to revoke that was filed and came before the court, and he was ordered to go to relapse safety, and he absconded, and he never went to relapse.
So he wasn't in custody?
No.
Okay. And then, so we didn't see him again until August 11th of 2023, when he was arrested in Houston. So here's the thing. Whether you probably didn't get any paperwork. Come up here to the front, in the middle here. From at least October of 2022 until August 11th of 2023, you wouldn't have known about anything because you quit going to probation. You were an absconder. And the only reason we found you is because you were arrested in Houston for aggravated assault with a deadly weapon.
And here's the reveal. Mendoza didn't just miss appointments. He disappeared. For nearly a year, probation had no idea where he was until he popped back up with a new arrest for aggravated assault with a deadly weapon. This is where credibility collapses. The judge makes it clear. If you don't know about your requirements, it's because you chose not to show up. This isn't about system failure. It's about personal accountability. And the tone of the courtroom shifts instantly from sympathy to disbelief. What do you think? Should a new violent arrest automatically kill probation? No questions asked.
So this is the third time, it looks like to me, that you would have been given an opportunity to remain on probation. Gave you upfront time, continued you on probation. Courtesy supervision was sent to Harris County. And then we have the scram device issues still, alcohol violations, interlock violations, aggressive behavior, ongoing alcohol use. So if you didn't do the relapse safety, it's not anyone's fault other than your own, because if you didn't know about it, it's because you weren't going to probation. Mr. Nichols?
Judge, I think it's pretty clear. He was put on zero tolerance a couple of years ago, and here we are on the second time.
Third.
Multiple times.
Yeah.
And I don't know what else we could do. So obviously I agree with the probation department's recommendation for revocation. I think he's had more than enough chances, Judge. In fact, there's just one thing I want to make the court aware of. If I can call Ms. Martinez real
Yeah,
quick.
sure. Ms. Martinez, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Go ahead.
Ms. Martinez, you were supervising, well, Mr. Mendoza was on Harris County supervision, correct?
Yes, sir.
And you were back in October when he started having these violations and the warrant was issued. Did you advise him to turn himself in?
Yes.
And what was his response to you?
He had responded with an email that said, "Ha."
That was his only reply to you. Did I ask you to print me out a copy of that?
Yes.
Showing you what I marked the Stakes Exhibit 1 for purposes of this hearing. Is this a copy of the email with his reply to you?
Yes.
I'll tender to the defense attorney, Your Honor. I'll tender to the court for purposes of this hearing. I'll offer Stakes Exhibit 1.
It's admitted.
This might be the most shocking moment. When probation told Mendoza to turn himself in, his entire response was a single word, "Ha." Think about that. Instead of responsibility, he mocks the system. That email becomes the smoking gun of his attitude toward probation. Dismissive, arrogant, and defiant. The courtroom reaction is telling. Even his own attorney looks cornered. It's one thing to fail, it's another to laugh about it. Here's a question for you. Would you have given him any leniency after reading that email?
I have no further questions of her, Judge.
Right, anything
I have no
else?
other questions for Ms. Martinez,
Your Honor.
Your Honor.
Thank you, Ms. Martinez.
I think he wanted to address the court, but we never did because we
Sure.
talked with her.
Go ahead.
Would you like to tell the court? Do you want to tell the court?
Y'all saying I went to safety twice, I never went.
Nobody's saying you went to Safe twice. We're saying you went to
You're saying
Safe
I'm
Hold on,
absconding?
don't, listen. I'm gonna let you talk, but don't talk over me. We're saying that you went to Safe and then that you were ordered to go to the Safe relapse, but you never came and turned yourself in after that phone call where you were told that there was to be a warrant for your arrest. So no, you never went to Safe relapse. Go ahead.
She said I was supposed to turn myself in. That was after I did the 9 months where felony assault got dropped to a misdemeanor terrorist threat.
Mm-hmm.
So when I was here, y'all let me out. And then I was trying to work and they kept saying that I was messing with the scram device.
Okay.
So I was actually at work and she sent me a message to my phone. And I was trying to work and trying to pay, for the devices and stuff, since they were violating me for operating my truck without court permission.
Mm-hmm.
So that's when I just didn't turn myself in.
Right. So did you respond? Is that email, that was
Yes,
what,
ma'am.
that's what you thought about all that?
Yes, ma'am, I did actually say that.
You thought that was funny?
It's cause I was agitated and I was taking lunch at work, and I was trying to, do things, trying to make money to take the classes, but with being on the scram device.
Well, you had money to buy alcohol. You hadn't, because you kept drinking, because you kept messing, Mr. Mendoza, you have been given so many opportunities on this probation, and I understand that those things are expensive. However, if you had at any time stopped testing positive and having blood alcohol readings that were positive on those things, then you could have eventually gotten off of those. I don't keep people on those for very long.
And there it is, the judge's patience snaps. Mendoza talks about foot problems, scram device irritation, even working lunches, anything to explain away the violations. But the judge cuts through it all. You had money for alcohol, but not for compliance. That line says it all. It's the brutal reality of probation. Excuses don't matter if the behavior never changes. At 43 years old, Mendoza still tried to argue he wasn't responsible for his own choices. Do you think the judge was too harsh here, or exactly right to call him out?
If I can go
We're done.
to
At this,
another
we're done.
CPM,
No, we're done.
let me kiss
At
my
the-
ass.
Mr. Mendoza, turn around. You can say whatever you want, but you're gonna face me and you're gonna get your sentence. And if at this time I could give you more, I would, I promise you, but I can't. So I'm going to find that you entered your pleas of true to counts 1 through 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation, sentence you to 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you a certification of your right to appeal. This was not an agreement, so you do have some rights to appeal. Y'all need to sign that before you leave right now. You need to sign that you're getting a copy of it, and then we'll give you your copy, and then when you're done with that, you can go back with the bailiff.
And just like that, Mendoza's probation is revoked. The judge hands down 6 years in prison, the very sentence he once avoided by being placed on probation. After multiple chances, endless resources, and countless warnings, his luck finally ran out. This case highlights a hard truth. Probation is a privilege, not a guarantee. You can blame the system, the costs, the devices, but at the end of the day, accountability wins. So what do you think? Was 6 years too lenient for a repeat violator who mocked the system, or exactly what justice demanded? Let us know in the comments. Smash that like button if this breakdown had you hooked, and don't forget to subscribe for more explosive courtroom moments.